justice effectively, fairly, and without corruption or prejudice. The end team, the principle then, nearly envisages that members of the public aggrieved by the conduct of government officials should be able to lodge their complaints with the public protector, who will investigate them and take appropriate remedial action.
Mr. Manichiri, go back to my brother Ponan's judgment about the engagement. Now, part of the problem, and it comes back to the question three of us raised with you right at the outset, is we're a bit in the dark here, because as I understood it, Mr. Karim, at the stage that he was minister, gave an undertaking in Parliament. We don't know the full extent of the undertaking, but it seems as if he was ready and willing to engage and implement. I think he said implement. We're willing to implement. So at that stage, the minister in charge said, we will follow what the public protector says. Am I at least correct about that, because it's the next step?
Well, I don't recollect whether the statement by Minister Karim is fully reproduced, and that it implies that there was not going to be any qualification.
But he did say they would implement. He did say they would implement.
As I understand.
Right. Yes. Now, as I understand the answering papers, and you must correct me if I'm wrong, if I recall the answering papers correctly, they are as follows: that we have continued to engage with the public protector, and we have put to certain points of view. Now, that engagement is an engagement that we are not privy to, because none of that is provided, is it?
No, you don't have the details.
Well, that's exactly
what the engagement would have been.
Well, that's exactly the problem. That, one would expect, would be dealt with, or ought to be dealt with, when you have the record of review proceedings in the review part. Yes. So could I just ask you again, we're having this debate about each of the issues that you raise, and rightly so, because, and I want to put to you again, if we conclude having regard to those issues, because we're going to have regard to those issues when we deal with a lower threshold, if we're dealing with interim.
Yes.
Do you accept that if we're against you on, well, I don't know that we could be against you conclusively, decisively, if we dealt with it on an interim basis, because we'd have to say they've established a case open to some doubt, because that would be the threshold.
Yes.
We'd get to that. But they would deal with each of those issues, and you could, either there's a finding in your favor, or there's a finding against you. And if there's a finding against you, an order of suspension could follow, without the other difficulties. So we won't decide the issues that have to be dealt with in the review. Is that at least technically feasible?
As I submitted earlier, we would submit to the court.
Yeah, no, I understand that. I'm not asking you to retreat. I'm just saying
not on the. Yeah.
It's a possible outcome.
It's a possible outcome if the court were against us on the submission that it wasn't open to the court to take the decision itself to suspend. And if it was something, a remedy that was open to the court, and this court is convinced that on a lower threshold that could have been granted.
No, but on a lower threshold, let me just ask you, if on a lower threshold we were to find that the facts were such that there was cause for concern, that at least the issues that have to be dealt with in the review were open to debate and discussion, and that there at least is something there to answer. That's all that we need to do, isn't that right? On the lower threshold.
Except that the order for suspension in the application as brought before the High Court was not linked to the merits of the review application in Part B, as one would have in that
no, but it can't be brought in vacuum, Mr.
No, it was brought on the basis that the public protector says discipline, and the consequence of that recommendation is that you must suspend in the meantime. Right. So it was not linked as one would have, like in the Air Road Express situation, where you say, I've got a good case on review, give me interim relief pending that review. That was not how the case was framed. The case was, the Part B was almost self-standing and not premised.
But that led to the confusion that we find ourselves.
That led to the confusion that the court then granted.
Granted relief preempting Part B, didn't it?
Yes,
at least in part.
So our submission is that on what was pleaded, it would not be appropriate for this court even to grant the holding relief, temporary suspension.
But why even not? I mean, look at the notice of motion.
Yes.
Look at paragraph 2. directing that he be suspended and shall remain suspended at least until the finalization of the disciplinary proceedings to be brought against him, and the determination of the relief sought in Part B. Actually, your response to my brother Nafsa was not entirely accurate.
No, perhaps I should have, that might be correct, Justice Ponin. What I should have said is, although the relief sought links the two, the basis on which the application was brought was not linking the two.
It was interim. It was pending two things. First, the disciplinary proceedings, and second, finalization of Part B.
What I'm submitting to the court is, in a way, the relief frames it like that, links the two, but the basis of the application was...
I'm suggesting to you that it's not just a linking of the two. What was initially sought was interim relief in Part A.
No, the suspension is unrelated to the outcome of Part
Let's
B.
give you a carrot. Let me give you a carrot.
Yes.
If you look at paragraph 2.
Paragraph 2 of the notice of motion.
Read for the moment, just read the following with us.
Yes.
Directing that the seventh respondent is suspended with immediate effect from his position as Chief Operating Officer and shall remain suspended at least until the determination of the relief sought in Part B. That's the carrot.
Well,
and
yes.
Why is that not feasible?
That's feasible only if the court will find that there is a basis made out.
No, I'm not asking you to retreat, Mr. Maneche.
Yes.
All we're asking you again, it's a possible outcome.
It's a possible outcome.
It would be competent relief, and there wouldn't be discord between that relief and the relief originally sought in the notice of motion.
Yes.
Would you accept that at least?
I accept that, subject to the case being made out for that.
Well, can I give you another carrot? No, but this is against Mr. Katz, because it's this, that the disciplinary proceedings themselves, in a sense, almost preempt the review conclusions,
yes.
Because who knows what they throw up. I mean, I see Mr. Katz is shaking his head vigorously, but could we just look at it from this perspective? There's a whole range. As I said, the kitchen sink is thrown at them in the review proceedings in respect of all of those issues. There's questions of nepotism, enriching himself, all sorts of stuff. So all of that's made out. What I'm putting to you is, and it may well be for you the lesser of two evils, and it is a holding exercise. And that's what interim relief usually is. It's a holding exercise.
Yes. Yes. As I submitted earlier, on the face of the notice of motion that Justice Ponin put to me, that's a relief they sought. But my main submission is that they didn't make out a case for that.
All right, so you're really saying on the merits they can't get by on interim relief. They
can't get by on interim relief pending Part B because the two are really delinked. Because the suspension is on the basis that there is administratively a requirement on the part of the SABC to get him out of the SABC because on the usual requirements for suspension, he might interfere with investigations or interfere with disciplinary conduct. Action that's taken against him.
Sorry, I keep interrupting you and cutting you short. Unless one wishes away entirely the Public Protector's report, why would they not have been entitled to interim relief?
Well,
in other words, you've got to take that out of the picture completely. You've got to wish it away. For as long as you say it is there, it's got to be taken into the reckoning. Why would they not be entitled to interim relief?
Because the Public Protector never says in the report that the continuous presence of Mr. Motsoeneng at the SABC would interfere with any investigations or disciplinary action. In fact, the Public Protector has regard to the personnel regulations of the SABC that allows for suspension.
But did she have to go that far?
Well, if
she makes serious findings against the man. And as I say to you, on the strength of that, why wouldn't one be entitled to interim relief against him?
Because what the Public Protector is looking at are, in her findings, all of those matters are historical. Are historical. So they're things that happened prior to when the Public Protector conducted the investigation. Now,
yeah, the point though is, I'm not sure what one makes of the fact that it's historical. It may have become historical because of the conduct of the SABC board.
The reason I say why it's significant that it's historical is that when you exercise the power to suspend, you inquire whether it is necessary to suspend the employee irrespective of the conduct that has been committed. In other words, is it required administratively because there is a risk that they may interfere with further investigations or interfere with the conduct of the disciplinary inquiry, either intimidating witnesses and things like that. That's the substantive basis on which generally courts would uphold a suspension, is that there must be a substantive substantially fair basis.
No, isn't that what the DA is saying? Isn't that what the DA is saying? That historical context is what could compromise the integrity of the disciplinary.
But they make no case for that. They do say that. They say, based on what the public protector has found, it's necessary, it's in the interest of the SABC to suspend. But they never engage with currently what it is on the part of Motsoeneng within the SABC that would require a suspension, a holding suspension, because there may be interference.
But usually as well, those considerations may pale into insignificance when one has regard to the seriousness of the allegations.
I accept
Do you accept that?
Yeah, I accept that.
Yes.
I accept that. And the second point in respect of the suspension also, we submit that along the lines of what the court said in the full case involving General Nduli, that where the power in the first instance resides, in this case with the minister, the appointing authority, to exercise the discretion whether to suspend or not. And that discretion has not been exercised yet and subjected to judicial review. It is inappropriate for the court to step in and take the power and exercise it and impose a suspension as it is what the DA asked the court to do in the High Court. And that is what is being put to it. And we would submit that the reasoning in that judgment, and perhaps I could read.
Well, perhaps we should deal with it for instance. Let's deal with it for instance.
Yes.
Let's assume that there are serious allegations made against the head of a police unit or a prosecuting authority or something else. And let's say in terms of that legislation, and these are serious allegations and they seem at least to be a basis for those allegations. So it's not just pulled out of the air. There's documents provided to the court, and in each of those instances there is a power along the line to suspend, which is not by a functionary or an official or a higher up.
Yes.
And that process is either delayed or is obstructed. Are you saying when a citizen with an interest comes to court and says, I know that I'm not the suspending party, but I'm telling you now, if you let any of these agencies continue, it'll be to the detriment of South Africa. Are you saying the doctrine of the separation of powers says, you court can't come and say, well, hang on, for the moment, it just seems to be enough to grant an interim interdict, that we couldn't do that?
No, I wouldn't make that submission. But the operative proposition put to me is you've got a frustration or obstruction of the exercise of the power to suspend. In other words, there's a case to suspend, but it's been obstructed. That might be a case in which there are either compelling reasons or exceptional circumstances for the court to take over the power and exercise it. But our submission is this, that in this case, what you had is a public protector report which considered the fact that there are personnel regulations in the SABC that empower suspension. But this chose, despite all the findings made, not to take the remedial action of suspension.
Well, could we start with a base about what is thrown up in this case? You have Minister Karim who says, I will implement. Now, you may be right. We don't know the full extent of that qualification. Nobody tells us, but on the face of it, he says we will implement. You have a minister who arrives. The public protector's report has been made available. The chairperson says to the minister, well, what are we going to do? And she says, well, I shouldn't be part of it, but you go and decide. And she comes back and she says, we've decided to appoint. Now, on that basis, the path upwards has already been taken. There's been no extensive, there's been no engagement with the public protector, and I'm just talking to you about it on the lower threshold for the moment,
Yes.
forget the higher threshold. So in that case, why could an order not ensue if that was the view one took of it? Of course, you've got a different perspective, but that is a perspective. Why couldn't you take a view on that perspective and say an interim order could ensue?
Well, if the court were persuaded that those set of circumstances bring this case into the realm of the compelling reasons which the court refers to in the Mdluli judgment or exceptional circumstances in other judgments, that might be a path open to the court to do. But our submission is simply that one has to look at the nature of the case that was brought, and that case simply said because there are findings by the public protector, there is a necessity for suspension.
But you see, it's dealt with by the court of appeal.
Yes.
If you look at paragraphs 95 and 96 of the judgment, at page 812.
I beg your...
Page 812.
812.
Paragraphs 95 and 96. I'd like you to tell me what is wrong with those conclusions. What the court of appeal says, the allegations of misconduct against Motsoeneng are serious. He is the COO of the SABC. He is an executive member of the board. He has virtually unlimited authority over his subordinates and access to all the documentation in relation to the charges of misconduct that will be preferred against him. Given the nature of the allegations and the persons involved, referred to in the report, Motsoeneng's fellow board members and his subordinates would have to be interviewed and documents produced. What this shows is that unless he is suspended, Motsoeneng poses a real risk not only to the integrity of the investigation concerning the allegations of misconduct, but to the disciplinary inquiry itself. It is untenable that he should remain in office while disciplinary proceedings are brought against him. What is wrong with those conclusions?
What's wrong with this is that it's not supported by facts that were put up by the DA. So in those facts, you don't you do have the first part about this.
Could I just ask you this?
Yes.
Is any state party here, state institution party here, suggesting that the public protector was dishonest? I don't understand that they are.
No, we don't see.
So at best, they're saying she's mistaken. At best. All right?
Yes.
Now, in the light of that, why don't you cross the lower threshold? If what we're putting to you is you have somebody who's not accused of corruption, who is the public protector. You can't say she's dishonest. You can't say that the investigation was conducted in bad faith. So the best you can do is to say, well, we think she's mistaken. But at that moment in time, why is the court not entitled to say what my brother Swain put to you?
One can't tick all the boxes in paragraph 95 and 96, and that's the proposition, is that whereas all of these are considerations that one takes into account in deciding a suspension,
But
what you have...
While he's not suspended, he's in control.
Well,
He's in control over his subordinates. They have to be interviewed. There's documentation that he has control over. Surely, one doesn't have to spin it out in evidence. One can draw that inference from the nature of his position.
well, if the court readily draws, but we would submit that where
He
one
has no control over his...
No, I'm not saying that.
Yes. You say
He's
he
the
has no control over documentation.
There is no risk. No, I don't say that. I'm saying there is no evidence showing the risk that he poses a risk to any further investigation or disciplinary inquiry. But if the court takes a different view on that, that's the view the court
But
takes.
you see, and that is why I said, unless you wish away the public protector's report in its entirety, it seems to me that there is enough for this low threshold that my brother Nafsa keeps referring to. Because did the public protector not find that he was allowed by successive boards to operate above the law?
Well, yes, she does.
And then there are some serious findings about him as well, and the propriety of his conduct in relation to a range of matters. Now, on the strength of that, coupled together with the reasoning of the High Court that my brother Swain has put to you, why, when one has regard to what the public protector said in her report and the reasoning of the High Court, on what basis can one possibly assail the reasoning of the High Court?
And coupled also with the upward mobility of the man involved,
That's the June appointment, the July appointment.
And the failure to institute disciplinary proceedings.
May I put it this way, Justice Patti, that the submission we make is simply, if the court found that on this fact, the court is within the paragraph 51 of the full judgment, that these are compelling reasons on a lower threshold basis, and it can step in and exercise the power, and it's simply a holding suspension pending the outcome of Part B.
Can I just raise this with you?
If I can just close that.
Yes,
the submissions are what I've made. And our main submission is the conclusions that the court makes in 95 and 96 are not underpinned by facts other than the public protector and the seriousness of the findings.
No. The first part, I understand that you might have qualifications about some of the conclusions.
Some of the findings.
But certainly the first part, which is in general terms, I don't think you can take issue.
I'm not taking issue with the fact that if one accepts the findings of the public protector, that's serious misconduct.
Could I just put you two more issues? My brother presiding put you the upward mobility, which was really the increase in salary, I think, 67% one year, and the positions.
That went up from 1.5 to 2.4 million rands in one fiscal year, I think it was.
And if you take into account, I mean, that explanation about his matric certificate, I know you say, and I think the minister says, but I looked at the transcript.
Yes.
But I mean, even on his own version, there's cause for concern. Even on his own version, there's cause for concern. I knew I didn't have a matric, but I spoke to some bureaucrat in the SABC, and I thought, let's just put it in. And you know, when you're talking about integrity of the institution, so we're talking lower threshold here. We're not talking, I mean, you know, if you want to go the skipper's way, and that's why I said it may be better for the state institutions to abide the lower threshold and go with a less breadth of remedy.
Justice Nafsa, as I submitted, to the extent that the court differs with our submissions as to the facts and the application of a lower threshold, and that these are compelling reasons and is an exceptional case, which is what would have to be determined to get into the full judgment, I've made my submissions.
You've made your submissions.
Can I just raise this? We're dealing with the public broadcaster. We're not dealing with the state broadcaster.
Yes.
Now, one would think that insofar as one is dealing with the public broadcaster, there would be overarching concerns of public interest. And yet, it seems, as a public broadcaster, when faced with all of this, you don't appear to have acted in the public interest.
Well, our submissions are different to that, Justice Ponen, because...
Well, wouldn't it have been in the public interest to disclose the contents of the Nkunu report?
As Justice Nafsa repeatedly pointed out, all of these matters are fully canvassed in the Part B review, and the Nkunu report is disclosed there. So all of these matters will be...
My opponent's asking about good faith on the part of a public entity.
Yes.
Now, your client relies extensively on the so-called Nkunu report to justify its failure to comply with the public protector's recommendations. But nowhere is the contents of that report disclosed.
And you claim legal privilege.
Yes.
But I mean, you're a public broadcaster in a sense. If you know, I'm not quite sure. It's our broadcaster. It belongs to all of us. Whose privilege is it? I mean, that's the one thing. But it's a serious thing. It's also the question of we've engaged, but you don't tell us how you've engaged. If you did, perhaps we'd be better off. Taken into account what my brother presiding told you, all these other instances of pay. I must say, I mean, that pay increase of 67% in 1 year for somebody who doesn't have a matric is an incredible thing. I mean, it might be as much as perhaps even more than what we earn. You've got to say to yourself, well, there's a basis for concern. At the very least, there's a basis for concern.
May I just deal with the question of engagement? The point about it, Justice Nafsa, is that at the time when the High Court application was brought, the full response from the SABC to the Public Protector in that context of engagement was still to come, because the date was to come after the High Court application. And that is why in the answering affidavits, the SAB is not able to put chapter and verse of what the engagement was or
Well,
would be.
Mr. Maniche, finally, you've said you've ended it, but I'm just asking you, perhaps you might consider very seriously the less broad.
As I said, I'll take instruction on that. I've made submissions in respect of that.
In respect of a question that I asked you earlier
Yes.
about whether the public protector directed the SABC to act in a particular way, let's have a look at page 202,
Yes.
volume 1, paragraph
volume
11.
So,
Volume 1,
yes,
paragraph 11, page 202.
page 202. Yes, I am there. That's the point about remedial action.
Yes. Appropriate remedial action to be taken as envisaged. Can I put in there which is to be taken or which must be taken? Would it be fair to
I
put
think
that in
it
there?
would be fair. That's how she's writing the report.
Would
The
that
public
be a
protector is writing the
recommendation?
report.
Would that be a recommendation or a direction?
As I submitted to you, let me submit it this way. The manner in which the public protector couches the remedial action in the report would not determine the status of that of the remedial action. What determines that is the anterior question of what remedial action means under Section 182. And if the
Isn't it really what was her intention rather than the status?
The intent. Well, her intention in the report may quite clearly be you must comply, you're bound to comply.
Exactly.
But whether or not that is the legal effect of what it carries, the legal effect that she intends, depends on the anterior question of what Section 182, 1C envisages. If it doesn't envisage that she gives binding directives, if I can put it that way, and bearing in mind in the first sense, in the sense of a court order, that you must follow it. If the court finds that is the meaning of remedial action under 182 of the Constitution, even if she couches
I'm sorry, I lost you for a bit.
So what I'm saying is how she couches the remedial action in her report, in other words, that she puts it in mandatory terms, doesn't determine whether it has the legal effect that it must be complied, it is binding, it must be complied with, in the first sense of a court order. But I've already accepted that it does have binding effect in the second sense, the lesser sense, that if you don't accept it, if you don't implement it, you must justify why you're not implementing it.
Okay.
Which is what the High Court has effectively said.
Will we say the same thing with 11.3?
11 point.
On the next page. The SABC board to ensure that.
Yes.
Would it be correct to put in is to ensure that?
Yes. I think that's really what the language says.
Yeah.
All I'm submitting to the court is the language doesn't help us determine the real question about the legal effect of a remedial action.
Well, she's taking remedial action which she can do in terms of Section 182(1)(c).
Yes. Whether the public bodies such as the SABC can say, on assuming for present purposes, for argument's sake, on a rational basis we're not accepting the findings, whether that is a course of action that is lawful and open to the SABC depends on the meaning of Section 182.
But this can't be said to be a recommendation.
No. I'm not suggesting that.
Yes.
I'm not suggesting that in her own report the public protector makes recommendations. That's not what I'm suggesting.
And you are not suggesting either that she's exceeded her powers, are you?
Well, we haven't. That's not the argument that the SABC made in the answering affidavit.
No, talking about from the bar in this court. You are not.
To the if she
you are not submitting that she exceeded her powers, because I mean that would be a traditional review ground.
Yes,
and we don't have a review.
You don't have a review. So there was no review in the High Court by the SABC.
So then, taken together with what my brother presiding has put to you, you ought to have complied.
Except that our submission is that it's binding in the lesser sense, in the sense that it is not of the nature of a court.
Forget about the term binding.
Okay.
It confuses things.
It does. So
you couldn't ignore it.
We couldn't.
What was expected was that you would give effect to it. That's your claim.
Unless you have a rational basis to differ with the findings. And you
No, well, I'm not sure about that. I mean, how do you determine a rational basis?
well, you've got to justify. Now we,
No, are you on the receiving end of this supposed to determine whether or not you are free because you subjectively perceive this to be irrational to not abide?
well,
I mean, that would be an alarming proposition, I must say, speaking for myself.
No, I'm not suggesting that. What I'm submitting is if the, as it happens in this case, the SABC didn't implement on the basis that it doesn't accept the findings and it's challenged in court for not implementing, if it has a rational basis, if one accepts that what it has put up is a rational basis for not implementing, then that we submit
But
would
then
not
if
be
that's
enough.
your answer to my brother presiding, and because the last part seems to be laced with court action, therein lies the problem. But there's another problem. You've accepted that there's a watchdog. And as I understand women, they talk about the guard guarding the guards. Well, what you want is the guard being guarded to now guard the guard who's guarding. I mean, that's really what you're doing. You're having a parallel process. You're saying, well, hang on, I know you were put to supervise us. And you've now come up and you've said we're in a bad space and we've done bad things. But you know, who are you? We're going to have our firm of attorneys who, by the way, don't stick with you. They say that's not what their mandate was. At least that's what the reports seem to be. They don't say, well, that's what we did. They say we did something lesser. But how can you, I mean, it would go on forever. Everybody having a second guess here. If you're unhappy with a public protector in the way she goes about her stuff, you have a host of remedies at your disposal.
Can I just use the first remedy under 11.3 to illustrate the proposition we make? And we're not suggesting
But my brother
that,
referred to, yes.
yes, we're not suggesting that the guard suddenly becomes the one that's guarded. But I understand the proposition being put to me. Now, in 11.3.1, for example, the remedial action she takes is all monies are recovered which were irregularly spent through unlawful and improper actions from the appropriate persons. There may be other similar, for example, if she finds maladministration in the award of a tender, she might say you must ensure that you cancel this. Now, let's take 11.3.1. All we're submitting is in that there is a discretion, maybe discretion is the wrong word, that in 11.3.1, when the board considers complying with this remedial action, it can seek legal advice to determine whether indeed there is a basis to recover monies.
Well, could we go back to the heading at the top of 11.2?
Yes.
We said that you accept, at least for the very basic premise, that Mr. Karim said he would implement. Well, this is for him, isn't it? 11.2 is for him, isn't that right?
Yes, it is.
So all of those fall under it. It's up until 11.2.4. So each one of those is what he can't implement anything else in respect of this report. Now, even assuming that you can qualify it in some way, if he said I'm going to implement, which one of from 11.2 to 11.3 to 11.2.4 could you exclude? And therein lies the problem. You've got one minister who says, that's what you've told me to do, I will implement. You say, well, that's not the full text. But what he was asked in essence to take one thing, one step, and that related to the position of Mr. Motsoeneng.
Can I just to correct something that I said about Minister Karim? I'm speaking from recollection that about whether the statement is fully reproduced in the papers. If it is, and I may be corrected later, I will accept it.
Can you find where it is in the founding?
No, but
I'll find it.
It's really in the Public Protector's answering affidavit, which was filed somewhat belated.
Yes, we'll find it.
And she makes reference there to the fact that there was an undertaking given by the then minister, who was Mr. Karim, that to Parliament, not to her.
Yes. Can I just go back in answer to the propositions put to me, to the example that I wanted to give, simply to illustrate the proposition. And I make the submission not to avoid the consequence of what the Public Protector has said must be done, but in order for the court to appreciate when it makes its judgment ultimately about the legal effect of the Public Protector's findings, to understand the differences in the arguments made by the various parties. The Corruption Watch, for example, takes the extreme position that there is no discretion left on the part of the public body. The public protector takes the remedial action for the public body. And I just want to illustrate that that's the one extreme end. And by reference to 11.3.1, show the court in our submission that, in fact, what is intended here is that in section 182, and that is reflected by the nature of the remedial action also, is that where, for example, you have this remedial action that recover monies, the public body is entitled to seek advice on whether there's a basis to recover the monies. And if it finds that there is no basis, either claims are prescribed or there is no one who is liable, that public body can say to the public protector, this is what you recommended, we can't implement this, and that's the part of the engagement.
Just remind me, at some stage in the papers, there was an allegation made that the Nkunu report would be made available to the public protector.
Yes.
That was in the minister's affidavit.
That's right.
In fact, you claim privilege in relation to that, but you seem to have made it available to the minister. Now, I'm not sure how you can claim privilege and make it available to the minister, who in turn undertakes to make it available to the public protector. Whether that has happened, we don't know.
Well, that might have been a claim wrongly made by the SABC, but as I submitted earlier, in relation to the kitchen sink proposition, that it's all in there in the second part, and it will all be canvassed.
But you know, the one thing I'm having some difficulty with this, and this is at a conceptual level, on what basis, when you're confronted with the report of the public protector, can you undertake a parallel investigation process?
Well, that's the point I was making by reference to 11.3.1, that it is not that it's like a court order. Unless you appeal, you implement as it is. You are, as a public body, you do need to inquire, to seek advice, to inquire into whether it is feasible, there is a basis.
That's not all that happened here.
That's the point.
In other words, they didn't just say, well, we need to determine, when she says irregular expenditure, we need to determine what the quantum of the irregular expenditure was. And we need to determine whose unlawful actions one is talking about. The attorney concerned, who I must say, appeared to have represented your client in relation to the public protector's investigations. Suddenly, that attorney is now appointed to conduct a process which is really parallel to the process earlier undertaken by the public protector. And then your client's attitude seems to be, well, actually, we prefer the outcome that our attorney has arrived at. And so guess what? We are now going to ignore you, Ms. Public Protector.
That's where the problem is.
But I understand where the problem, as the court articulates. The earlier submission I was making was at the conceptual level. I was trying to respond to the conceptual proposition about how the public body reacts to findings and remedial action, that the public body is entitled to assess whether it is implementable. For instance, there's a basis to implement.
And you say provided their decision not to implement it is rational, then that's excusable.
That's our submission.
And you derive that from the decision in Bradley?
The court
we derive from the controlling principle that all exercises of public power must be
Bradley is
rational.
inapplicable.
No, we accept. I'm not importing Bradley as the sole basis or the basis for the submission. Is because it's a public body. You're exercising public power. You're rejecting a report performed by a constitutional institution. There must be you must comply with the principle of legality. That's the basis of that submission.
Would this be a convenient time to take the adjournment?
It would,
Yes, the court will adjourn for 15 minutes.